The mockery in Attorney Caldwell's voice was unmistakable as he gestured toward the woman at the defendant's table. "Your Honor, opposing counsel appears to be, how shall I put this delicately, unqualified for these proceedings." His colleagues chuckled as they watched the plainly dressed woman organize her simple manila folders. Her crime? Daring to represent herself in a complex property dispute against the city's most prestigious law firm. Then she stood to speak. The Latin that flowed from her lips was so precise, so elegant, that Judge Harrison rose from his bench in shock. The arrogance in Caldwell's smirk vanished instantly as he realized his terrible mistake. From which city in the world are you watching this video today? If you enjoyed this story, consider subscribing for more tales of underestimated individuals who prove that true expertise often comes without fanfare. But what happened next would change everything Caldwell thought he knew about power, expertise, and the danger of judging someone by their appearance. Because Magnolia Thorne wasn't just any defendant, she was someone who had spent decades in rooms where million-dollar decisions were made with a single sentence, someone who had shaped the very laws Caldwell claimed to understand. And she was about to demonstrate why the most dangerous opponents are the ones you never see coming. The morning sun filtered through the tall windows of Superior Court Room 14, casting long shadows across the polished wooden floors. The courthouse, built in 1887, retained its imposing Victorian architecture, its high ceilings and ornate details designed to inspire both reverence and intimidation. Today, it would serve as the battleground for what most observers assumed would be a routine property dispute. Magnolia Thorne sat quietly at the defendant's table, her weathered hands folded over a collection of manila folders held together with rubber bands. At 63, she wore no makeup, her silver-streaked brown hair pulled into a simple bun secured with bobby pins that had seen better days. Her navy blue dress was clean but clearly inexpensive, purchased from a department store rather than a boutique. The fabric showed signs of careful mending, a small patch near the hem, threads reweaved where wear had threatened to create holes. Everything about her suggested someone overwhelmed by circumstances beyond her understanding. But appearances, as Magnolia knew better than most, could be devastatingly deceiving. She had chosen every element of her presentation carefully. The simple dress was one she kept specifically for occasions when she needed to blend into the background. The manila folders, held together with rubber bands rather than expensive leather binders, were a deliberate choice. Even her posture, slightly hunched, hands clasped nervously, was calculated to project vulnerability. 38 years ago, she had sat in a different courtroom, wearing robes instead of a simple dress as Chief Justice of the Connecticut Supreme Court. She had presided over cases that shaped state law, written decisions that were cited in law schools across the nation. Her opinions on property law had been referenced in Supreme Court briefs. But today, she was just another defendant fighting for her family's land. The irony wasn't lost on her. She had spent decades watching attorneys underestimate opponents, make assumptions based on appearance or perceived status. Now she was conducting her own masterclass in the dangers of such thinking. The plaintiff's table, in stark contrast, resembled a military operation. 3 attorneys in $1,000 suits arranged stacks of leather-bound documents with military precision. Computer tablets, expensive fountain pens, and briefcases that cost more than most people's monthly salary created an impressive display of legal firepower. Attorney Bradford Caldwell, senior partner at Morrison, Caldwell & Associates, reviewed his notes one final time. At 52, he embodied everything most people expected from a successful lawyer. His silver hair was perfectly styled, his Italian suit impeccable, his Harvard-class ring catching the light as he gestured to his associates. The case before him seemed almost insultingly simple. Caldwell's reputation had been built on crushing unprepared opponents. He was known throughout the legal community for his theatrical courtroom style, his ability to intimidate through pure force of personality. Corporate clients paid premium fees specifically for his talent at making problems disappear through legal intimidation. Today should have been another routine victory. He studied the woman across the aisle with barely concealed disdain. In his 30 years of practice, he had encountered every type of self-represented litigant. The angry divorcee convinced of her own legal expertise, the conspiracy theorist armed with internet research, the stubborn property owner clinging to sentimental attachments. Magnolia Thorne fit perfectly into the latter category, a simple woman who didn't understand that progress required sacrifice. "This shouldn't take more than an hour," he murmured to his junior partner, Mitchell Hayes, a sharp-eyed associate who had graduated second in his class from Columbia Law. "The woman doesn't even have proper legal representation. She's defending herself against a municipal development claim. It's like watching a child play dress-up in adult clothes." What Caldwell didn't know was that the child he was dismissing had written the definitive law review article on municipal takings that he had cited in his brief. She had crafted the legal precedent he was attempting to use against her. And she was about to remind him why thorough research was the foundation of competent legal practice. But the transformation that was about to unfold would shatter every assumption in that courtroom, because sometimes the most powerful people are those who choose to hide their strength until the moment it's needed most. Judge Harrison entered the courtroom with the measured pace of someone who had presided over thousands of such proceedings. At 68, he carried himself with the dignity of 4 decades on the bench, his black robes flowing behind him as he took his seat at the elevated platform that dominated the room. His reputation for fairness was legendary, but he had little patience for grandstanding or unprepared presentations. Harrison had seen every type of case, every variety of attorney, every form of legal drama. Yet something about today's proceedings felt different. Perhaps it was the stark contrast between the two legal teams. Perhaps it was the way the defendant sat with such stillness, such focused attention. Or perhaps it was simply the intuition that comes from decades of observing human nature under pressure. He had presided over cases involving Fortune 500 companies, high-profile criminal trials, constitutional challenges that made national headlines. But he had learned long ago that the most interesting cases were often the ones that appeared most mundane on the surface. Property disputes, contract disagreements, family matters, these were where human nature revealed itself most clearly. Today, he sensed, would be one of those revelatory moments. "Court is now in session," announced the bailiff, a stern woman whose voice carried the authority of someone who had maintained order in this courtroom for over 20 years. The Honourable Judge Marcus Harrison presiding. "Be seated," Judge Harrison instructed, his deep voice filling the courtroom. He surveyed the scene before him, noting the obvious disparity between the two legal teams. His expression remained neutral, but years of experience had taught him to be cautious about cases that appeared too straightforward. "This is case number CV 2024-4751, Morrison Development Group versus Magnolia Thorne," he announced, referring to his docket. "Counsel for the plaintiff, please identify yourself for the record." Bradford Caldwell rose with practiced confidence, his posture perfect, his voice clear and authoritative. "Bradford Caldwell of Morrison, Caldwell and Associates, representing Morrison Development Group and the City Planning Commission, Your Honour. With me today are my associates, Mitchell Hayes and Sarah Chen, also of Morrison, Caldwell and Associates." Judge Harrison turned toward the defendant's table. "And for the defence?" Magnolia Thorne stood slowly, her movements deliberate but not hurried. When she spoke, her voice was quiet but clear, carrying a slight accent that suggested rural origins. "Magnolia Thorne, Your Honour. I am representing myself in this matter." A ripple of whispers spread through the gallery. Several law students who had come to observe complex litigation shifted uncomfortably in their seats, recognizing they were about to witness what would likely be a one-sided legal massacre. In the back row, Professor Sarah Montgomery from the local law school leaned forward with interest. She had brought her constitutional law class to observe what she expected would be a straightforward property dispute. Instead, she was beginning to sense something far more intriguing. The gallery held an interesting mix of observers. Besides the law students, there were several older attorneys who had come out of curiosity, drawn by courthouse gossip about Morrison, Caldwell and Associates taking on a self-represented defendant in a high-stakes property case. Court watchers, retired lawyers who attended proceedings for entertainment, filled several rows. And in the very back, almost invisible in their careful anonymity, sat two figures who seemed oddly out of place yet perfectly at home in the formal setting. What none of these observers knew was that they were about to witness legal history in the making. Not the kind that makes headlines, but the kind that gets whispered about in law school corridors and remembered in judicial chambers for decades to come. But first, Caldwell would have his moment of theatrical dominance. And Magnolia would let him take it. Caldwell couldn't resist a theatrical sigh, loud enough for the court reporter to glance up from her machine. His voice carried the particular condescension he reserved for opponents he considered beneath his notice. Your Honour, before we proceed, I feel compelled to note that opposing counsel, that is, Miss Thorne, appears to be proceeding without adequate legal representation in what is a highly complex property law matter involving municipal development rights, federal regulations, and interstate commerce implications. He paused for effect, letting his words settle over the courtroom like a blanket of professional superiority. While I certainly respect Miss Thorne's right to represent herself, I fear that the complexity of these proceedings may be challenging for someone without extensive legal training. What Caldwell didn't notice was the slight tightening around Judge Harrison's eyes, or the way Magnolia's hands stilled completely on her folders. He was too focused on his performance, too confident in his assessment of the situation. But if he had been watching more carefully, he might have noticed that Magnolia didn't look nervous or intimidated by his words. Instead, she looked interested, like someone watching a chess opponent make exactly the move she had anticipated. Judge Harrison's eyes narrowed slightly at the condescending tone. 40 years on the bench had taught him to recognize when attorneys were performing for the gallery rather than practicing law. Mr. Caldwell, Miss Thorne has the right to represent herself. Please proceed with your opening statement. Of course, Your Honour. Caldwell returned to his table, exchanging glances with his associates that clearly communicated his confidence in the proceedings' outcome. Ladies and gentlemen, this case is fundamentally about the greater good. The Morrison Development Group, in partnership with the city, seeks to develop property that will bring jobs, tax revenue, and economic growth to our community. He gestured toward a professional display board showing architectural renderings of a proposed shopping complex. The defendant's property, while sentimentally valuable to her, represents an obstacle to progress that would benefit thousands of residents. The law is clear regarding eminent domain, the compensation offered exceeds fair market value, and the public benefit is substantial. For the next 20 minutes, Caldwell presented a methodical case supported by recent precedents, economic impact studies, and municipal planning documents. His arguments were polished, his delivery confident, and his legal foundation seemingly unshakable. He cited Morrison v. Development Authority with practiced ease, referenced the Commerce Clause implications of local development projects, and quoted extensively from recent appellate decisions favouring municipal development rights. During his presentation, Magnolia remained perfectly still, her hands folded, her expression attentive but unrevealing. To the casual observer, she appeared to be struggling to follow the complex legal arguments. She occasionally made small notes in the margins of her manila folders, but her writing seemed hesitant, uncertain. What the courtroom couldn't see was that her notes weren't recording Caldwell's arguments. Instead, she was cataloguing his errors, the misquoted statute references, the precedents he cited but clearly hadn't read in full. The constitutional interpretation that revealed a fundamental misunderstanding of 14th Amendment jurisprudence. Each mistake was carefully noted in handwriting that, despite its appearance of uncertainty, was actually the precise script of someone who had spent decades making judicial notes. She was building her response methodically, professionally, devastatingly. When Caldwell concluded, the outcome appeared predetermined. He had presented what seemed to be an airtight case, supported by recent precedents and compelling economic arguments. The murmurs from the gallery suggested widespread agreement that the defense would be a mere formality. But then something shifted in the courtroom's atmosphere, As Judge Harrison called upon Magnolia to present her opening statement, she rose from her chair with movements that seemed somehow different, slower, more deliberate, more authoritative. "Miss Thorne," Judge Harrison said, his voice gentle but formal, "you may present your opening statement." And this was the moment everything began to change. Magnolia stood once again, this time moving to the podium that seemed to dwarf her small frame. But as she walked those few steps, something remarkable happened. Her posture straightened almost imperceptibly. Her movements became more assured. When she reached the podium and turned to face the courtroom, the uncertain defendant had begun to disappear, replaced by someone else entirely. She carried with her only a single manila folder, its contents invisible to the courtroom observers. For a moment she stood silently, her eyes scanning the faces before her. The silence stretched long enough to become uncomfortable, long enough for people to shift in their seats. When she finally spoke, her voice was different. Still quiet, but with an underlying strength that hadn't been there before. "Your Honor," she began, and the change was subtle but unmistakable. "My family has owned this land for 143 years. We purchased it in 1881 from the Weatherby estate under a deed that contains specific language regarding development rights and mineral extraction." The precision of her statement hit the courtroom like a small shockwave. Gone was the hesitant tone, the nervous mannerisms. In their place was someone who spoke with the authority of absolute knowledge. Caldwell shifted in his chair, frowning slightly at the unexpected specificity of her statement. He had reviewed the property records thoroughly and remembered no unusual deed restrictions. His confidence flickered for the first time, but he was about to discover that thorough and actually thorough were two very different things. "The Morrison Development Group claims authority under eminent domain," Magnolia continued, "but their legal foundation rests on a misunderstanding of the property's true ownership status." She opened her folder and withdrew a single document, its paper yellowed with age. "This is the original deed, Your Honor, written in both English and Latin, as was common practice for significant property transfers in the 19th century. Judge Harrison leaned forward, his interest clearly piqued. "Approach the bench, Miss Thorne." As Magnolia walked toward the judge's platform, Caldwell rose partially from his chair, his composure beginning to crack. "Your Honor, if I may examine any documents being submitted as evidence." "You may review them after I do, Mr. Caldwell," Judge Harrison replied curtly, but his voice carried a new tone. Something had caught his attention about Magnolia's presentation, something that suggested this case might not unfold as predictably as everyone had assumed. He accepted the document from Magnolia, studying it carefully through his reading glasses. His eyebrows rose slightly as he examined the Latin text, and for a moment the courtroom held its collective breath. Here was the first crack in Caldwell's confidence, the first hint that his carefully constructed case might have fundamental flaws. The document in Harrison's hands was clearly authentic, clearly old, and clearly something that Caldwell's thorough research had missed entirely. "Miss Thorne," Harrison said, his voice carrying new respect, "are you able to translate this Latin passage?" And this was the moment Magnolia Thorne stepped fully out of the shadows of her assumed persona. "Yes, Your Honor." Her posture had subtly transformed. Her back was straighter, her voice more assured, her entire bearing suggesting someone completely comfortable with complex legal proceedings. The Latin reads, "Haec terra in perpetuum familiae Thorne conceditur, cum omnibus juribus mineralium et aquarum, nec ulla potestas civilis hanc concessionem revocare potest, sine consensu heridum." The Latin flowed from her lips with the fluency of someone who had not just studied the language, but used it professionally for decades. Each word was precisely pronounced, each phrase flowing naturally into the next. This wasn't someone who had hurriedly looked up translations online. This was someone for whom Latin was a familiar professional tool. The courtroom fell silent. Even the court reporter paused, her fingers hovering over the keys as she processed what she had heard. The transformation was so complete, so unexpected, that several observers actually leaned forward in their seats, as if questioning their own perception. Judge Harrison stood slowly, his face displaying a mixture of surprise and growing understanding. 40 years on the bench had taught him to recognize legal expertise when he saw it, and what he was witnessing went far beyond what any layperson could have prepared. "For the record," he said, his voice carrying new gravity, "would you translate that for the court? This land is granted to the Thorne family in perpetuity, with all rights to minerals and waters, and no civil authority may revoke this grant without the consent of the heirs." The words hit the courtroom like a bombshell. This wasn't just a property dispute anymore. This was a fundamental challenge to the entire legal basis of the municipal taking. Caldwell shot to his feet, his confident demeanour cracking like ice under pressure. His face had gone pale, his hands slightly shaking as he realised that his routine case had just become a potential career disaster. "Your Honour, this is highly irregular. We need time to verify this document's authenticity and examine the legal implications of—" "Mr. Caldwell," Judge Harrison interrupted, his tone sharp with growing impatience. "Are you questioning Miss Thorne's translation?" I would need to consult with a Latin scholar to verify." And then Magnolia delivered the blow that would end Caldwell's arrogance forever. She turned to face Caldwell directly, and when she spoke, her voice carried an authority that had been completely absent moments before. It was the voice of someone who had spent decades in rooms where million-dollar decisions were made with a single sentence. "Perhaps I can save you the trouble, Mr. Caldwell. Ignorantia juris non excusat. Ignorance of the law is no excuse." The transformation was stunning. The woman who had appeared overwhelmed and out of place now commanded the courtroom with quiet authority. Her pronunciation was flawless, her bearing suddenly dignified in a way that suggested decades of experience in exactly these kinds of proceedings. But she wasn't finished, not even close. "Furthermore," she continued, returning her attention to Judge Harrison, "the plaintiff's claim relies on Chapman v.'s Municipal Development Authority, but they have overlooked the controlling precedent established in Weatherby Holdings v. State of Connecticut, which specifically addresses perpetual grants with Latin codicils." She paused, letting the weight of her legal knowledge settle over the courtroom like a heavy blanket. The silence was profound. Even the casual observers could sense that something extraordinary was happening. Mitchell Hayes frantically began searching through his files, his face pale as he whispered urgently to Caldwell. The senior partner's confidence had evaporated entirely, replaced by growing panic and the dawning realization that he was facing an opponent he had completely misjudged. "Your Honour," Magnolia continued, her voice now carrying the measured cadence of someone who had delivered countless legal arguments, "if I may direct the court's attention to the precedent established in 1923 by Chief Justice Whitman in the matter of Ancient Holdings versus the City of Hartford." What followed was a masterclass in legal precedent. She cited case law with precision that would have impressed Harvard law professors, referencing specific paragraph numbers, dissenting opinions, and related statutes with effortless accuracy. Each citation was delivered with the confidence of someone who had not just read these cases, but understood their deeper implications and interconnections. The gallery had fallen completely silent. Even the law students who had come expecting a simple demonstration of municipal authority were now frantically taking notes, recognizing that they were witnessing something far more significant than a routine property dispute. Judge Harrison had returned to his seat, but his attention was completely focused on Magnolia's presentation. His expression had shifted from polite judicial attention to something approaching awe. In 4 decades on the bench, he had heard thousands of legal arguments, but rarely with such precision and depth of understanding. After several minutes of flawless legal exposition, he finally interrupted. "Miss Thorne, forgive my curiosity, but what is your background in Latin and property law?" The courtroom held its breath. This was the question everyone wanted answered. How had a seemingly simple defendant transformed into someone delivering legal arguments that would have impressed the Supreme Court? For the first time since standing to speak, Magnolia smiled. It was a small, almost self-deprecating expression, but it carried within it the confidence of someone who had spent decades in exactly these kinds of situations. I graduated summa cum laude from Yale Law School in 1984, Your Honour. I specialised in property law and historical land grants. I served as a law clerk for Justice Matthews on the Connecticut Supreme Court, and later as an Associate Justice myself for 15 years before retiring to care for my elderly mother. The revelation hit the courtroom like a physical wave. Gasps echoed through the gallery. Several attorneys who had been casually observing suddenly sat up straighter. The law students looked at each other in amazement. Professor Montgomery, who had brought her class to observe what she expected to be a routine proceeding, grabbed her phone to quickly look up information about Justice Magnolia Thorne. But the most dramatic reaction came from the plaintiff's table. Caldwell sank into his chair as if the air had been knocked out of him. His face cycled through shock, disbelief, and dawning horror as he realized the magnitude of his error. His associates stared in shock at the woman they had dismissed as an uneducated obstacle to their case. Mitchell Hayes actually dropped his pen, the small sound echoing through the suddenly silent courtroom. Justice Thorne, Judge Harrison said, using her proper title with obvious respect, "Why didn't you identify yourself as such when you entered your appearance?" "I retired from the bench 8 years ago, Your Honour. I am no longer Justice Thorne, simply Miss Thorne, defending her family's property." Her voice carried quiet dignity. "I believe my legal arguments should stand on their merit, not on past titles." Caldwell finally found his voice, though it cracked slightly. "Your Honour, regardless of the defendant's background, the city's authority under eminent domain is well established." "Is it, Mr. Caldwell?" Magnolia turned to face him fully. "Are you familiar with the decision in Calo v. City of New London?" "Of course, but—" "Then you know that eminent domain cannot supersede existing perpetual grants unless the taking serves a legitimate public purpose that cannot be achieved through alternative means. Can you demonstrate that this shopping complex serves such a purpose?" Caldwell's mouth opened and closed wordlessly. The shopping complex was clearly a commercial venture that would benefit private developers more than the public interest. Magnolia retrieved additional documents from her folder. "I have here correspondence from the Morrison Development Group discussing profit projections, private investor returns, and marketing strategies. Hardly the language of public benefit." "How did you obtain private correspondence?" Hayes demanded, finally finding his voice. "Discovery, Mr. Hayes. I filed proper motions and received everything I requested. Perhaps if you had taken my case more seriously, you might have reviewed what you provided me." Judge Harrison examined the correspondence, his expression growing more serious with each page. "Mr. Caldwell, this appears to be a private commercial venture using eminent domain as a tool for profit generation. Your Honour, the economic benefits to the community are substantial. The benefits to Morrison Development Group appear to be even more substantial," Judge Harrison replied dryly. "Justice Thorne, Miss Thorne has raised significant questions about the legitimacy of this taking." Magnolia returned to her table, her transformation now complete. The uncertain defendant had vanished, replaced by someone who moved through the courtroom with quiet authority. "Your Honour, I would like to call my first witness." "You have witnesses?" Caldwell asked, panic creeping into his voice. "Certainly. Dr. Margaret Westbrook, Professor of Legal History at Yale Law School." A woman in her 70s rose from the gallery, her credentials immediately apparent from her confident bearing and the respectful nods she received from court personnel who recognized her reputation. "Dr. Westbrook," Magnolia began after the witness was sworn in, "you've examined the deed in question. In your expert opinion, is it legally valid?" "Absolutely. The document is authentic, properly executed according to 19th century standards, and the Latin clauses create binding legal obligations that supersede later municipal authority." For the next hour, Dr. Westbrook provided scholarly testimony about historical property law, the legal significance of Latin clauses in deed restrictions, and precedents dating back to colonial America. Her expertise was unquestionable, her testimony devastating to the plaintiff's case. Caldwell's cross-examination was brief and ineffective. His questions revealed a man scrambling to understand legal concepts he had never encountered in his commercial law practice. "Miss Thorne," Judge Harrison said when Dr. Westbrook stepped down, Do you have additional witnesses? Yes, Your Honor. I call Professor James Richardson, Property Law, Harvard Law School. Another distinguished academic rose from the gallery. Caldwell turned to Hayes, whispering urgently, but his associate could only shake his head helplessly. Professor Richardson's testimony focused on eminent domain limitations and the constitutional protections afforded to property owners with historical grants. He cited Supreme Court decisions spanning 2 centuries, each one undermining the legal foundation of the plaintiff's case. Mr. Caldwell, Judge Harrison said when the testimony concluded, would you like to present rebuttal witnesses? Caldwell conferred frantically with his associates before responding. Your Honor, we would request a continuance to properly prepare. Mr. Caldwell, you initiated this action. Did you not research the defendant's property thoroughly before filing? We believed, the records indicated, standard eminent domain procedures seemed appropriate. Magnolia stood once again. Your Honor, if I may address the court's concerns about Mr. Caldwell's preparation. Please proceed. I provided Mr. Caldwell's firm with complete copies of all relevant documents 6 months ago, including the original deed with Latin translation, historical precedents, and constitutional analysis. They were also provided with my curriculum vitae, which clearly identified my legal background. She retrieved a thick folder from her collection of materials. These are certified copies of my correspondence with Morrison, Caldwell and Associates, including their responses dismissing my legal arguments as the desperate objections of an uneducated property owner. Judge Harrison accepted the correspondence, his expression growing increasingly stern as he read. Mr. Caldwell, it appears you were fully informed of the defendant's legal background and the strength of her position 6 months ago. Your Honor, the sheer volume of documentation, we assumed. You assumed, Judge Harrison repeated, his voice cold, that a retired Supreme Court justice didn't understand property law. The courtroom was silent, except for the soft scratching of the court reporter's machine. Caldwell's face had gone pale, his confident demeanor completely shattered. Magnolia returned to the podium. Your Honor, the plaintiff's case rests entirely on the assumption that my family's property can be seized for private commercial development. However, the legal documentation clearly establishes perpetual ownership with constitutional protections that cannot be superseded by municipal authority for private benefit. She paused, allowing her words to resonate through the courtroom. Moreover, the plaintiff's conduct throughout this proceeding suggests a troubling disregard for property rights and due process. They dismissed legitimate legal objections without investigation, proceeded with litigation without proper research, and attempted to use governmental authority to benefit private commercial interests. Judge Harrison nodded slowly. Miss Thorne, in your opinion, what remedy would be appropriate? I seek dismissal with prejudice, Your Honor, along with attorney's fees and costs. The plaintiff's action was frivolous and filed without adequate legal basis. Mr. Caldwell, Judge Harrison said, do you have any response to Miss Thorne's request? Caldwell stood shakily, his earlier confidence completely gone. Your Honor, while we may have misunderstood certain aspects of the defendant's legal position. You misunderstood, Judge Harrison interrupted, that she was a retired Supreme Court justice with expertise in exactly the area of law involved in this case. No, we should have. Mr. Caldwell, in 40 years on this bench, I have rarely seen such a failure of basic legal preparation. You initiated an eminent domain proceeding against property with perpetual grant protections, ignored clear constitutional precedents, and dismissed the objections of one of the state's most qualified property law experts. Judge Harrison paused, his expression grave. This court finds that the plaintiff's action was frivolous and filed without reasonable legal basis. The motion for eminent domain is denied with prejudice. Miss Thorne's property cannot be seized for private commercial development under any circumstances. He turned his attention to Caldwell's table. Furthermore, the plaintiff shall pay all defendants' attorney fees and costs. While Miss Thorne represented herself, her time and expertise in preparing this defense shall be compensated at standard rates for Supreme Court justice consultation fees. The gallery erupted in whispers and movement as the implications sank in. Morrison Development Group would not only lose their development project, but would pay substantial fees to the woman they had tried to force from her land. Mr. Caldwell, Judge Harrison continued, I strongly recommend that you and your firm review your case preparation procedures. The failure demonstrated today raises serious questions about professional competence. As court was adjourned, Caldwell and his associates gathered their materials in stunned silence. The case they had expected to resolve in an hour had become a professional humiliation that would follow them throughout their careers. Magnolia methodically packed her manila folders, her movements calm and unhurried. Several attorneys from the gallery approached her, their expressions mixing respect and curiosity. Justice Thorne, one young lawyer said, I graduated from Yale Law 5 years ago. Your property law seminar was legendary. I never imagined, she smiled warmly. Sometimes the most important cases are the ones closest to home. Thank you for attending today. As she walked toward the courtroom exit, Magnolia passed Caldwell, who was still sitting at his table, staring at the documents that had destroyed his case. Mr. Caldwell, she said gently, a word of advice from someone who has seen many lawyers make similar mistakes. Humilitas est virtus. Humility is a virtue. It's never too late to learn. He looked up at her, his face a mixture of shame and dawning respect. Justice Thorne, I owe you an apology. You owe me nothing, Mr. Caldwell, but you might consider treating future opponents with more respect, regardless of their appearance or apparent credentials. She paused. Some of us prefer to let our arguments speak rather than our titles. With that, Magnolia Thorne walked out of the courtroom, her simple navy dress and unassuming appearance unchanged, but her quiet dignity restored to its rightful place. Behind her, she left a powerful reminder that true expertise often comes without fanfare, and that wisdom should never be judged by appearances alone. The case would be studied in law schools for years to come, not just for its property law implications, but as a cautionary tale about assumptions, preparation, and the dangerous tendency to underestimate opponents based on surface impressions. And somewhere in a small house on land that had been in her family for nearly 150 years, a retired justice would tend her garden, secure in the knowledge that some battles are worth fighting, regardless of the odds.